All right, good afternoon, everyone. Welcome to the Pennsylvania Human Relations Commission's Fair Housing and Power Hour session. Our topic this month is Fair Housing Fundamentals. My name is Brittany Mellinger, and I'll be your presenter today. I'm also the Fair Housing Training and Outreach Coordinator at the PHRC. So first of all, I'd like to thank our ASL interpreters as well as a captioner for making this presentation accessible. I'm going to put the captioning link in the chat so that you are able to access captions for this presentation. But let's go ahead and get started. So we always start out our fair housing presentations by just reiterating that fair housing is the right of all Pennsylvanians. It's crucial for Pennsylvanians to be able to access fair housing free from discrimination. So we put a strong emphasis on this. To let you know what we'll be talking about today in the presentation, our goals are to be able to provide an overview of the work of the Pennsylvania Human Relations Commission, to identify relevant fair housing laws and protected classes, to discuss discriminatory practices, and to provide an overview of the complaint process. Throughout the presentation, we will allow for questions. So if you have questions, if you have comments, if you'd like to answer questions that I pose to the group, please feel free to enter that into the chat. You can also raise your hand if you would like to be unmuted to ask a question. But we will strive to dedicate 10 to 15 minutes at the end of the presentation to questions that arise throughout the course of the presentation. I do want to let you know that this presentation is being recorded, and this recording will be available at the end of the presentation. It typically gets sent out within the next few days, and we will also send out all of the slides, which include links to further information for folks who'd like to learn more or reference back to the materials after the presentation. All right, so we're going to start by providing an overview of the Pennsylvania Human Relations Commission, also known as PHRC. So we are the state's leading civil rights enforcement agency. We've been around since 1955, and we exist to make sure that Pennsylvanians can live, work, and learn free from unlawful discrimination. So we accomplish this mission in two ways. So first of all, we enforce Pennsylvania's non-discrimination laws. That includes both the Pennsylvania Human Relations Act as well as the Pennsylvania Fair Educational Opportunities Act. So if someone in Pennsylvania believes that they have experienced discrimination, whether it's in their housing or one of the other areas that PHRC covers, including employment, public accommodations, commercial property, and education, they can file a complaint with our agency. It's completely free to do so. And a neutral investigator will look into the situation to see if there's a violation of our state laws. But beyond reacting to complaints as they come in and investigating them, we also work to actively and proactively promote equal opportunity for everyone in Pennsylvania. So we do that through trainings like these, through in-person and virtual events, hosting speakers, really providing a lot of information and resources to communities to understand the rights and responsibilities and to advocate for equal opportunity for all in Pennsylvania. We also have advisory councils and social justice ambassadors, which are volunteer programs which help local communities connect with our state agency to provide information about folks' rights and responsibilities in their local communities, share information about how to file a complaint, host trainings, do all kinds of work in local communities. And we'd love to have you be a part of that if you're interested. So you can feel free to email me if you want some more information on that, or you can go on our website. We've got lots of information on how to get more involved with those programs that extend the reach of our agency. So we serve the entire state of Pennsylvania, and we do that through 3 regional offices. So that includes our Pittsburgh regional office, which you can see out there in the dark blue. We've got our central regional office, our Harrisburg regional office, And then in the southeastern portion of the state, there's our Philadelphia regional office. So these offices do the day-to-day work of accepting and investigating complaints. We also have a central office that does outreach and administrative functions. And I'd love for everyone on the call, if you're willing to pop your name in the chat and let me know where you're coming from throughout Pennsylvania, or even outside of Pennsylvania if you're joining us from outside the Commonwealth. It's always great to know where our audience is coming from since we're in this virtual space together. I also want to share a breakdown of our laws and what they cover. So the Pennsylvania Human Relations Act, that covers the bulk of our work. That covers employment, housing, commercial property, public accommodations, and primary and secondary education. And then the Pennsylvania Fair Educational Opportunities Act covers post-secondary education, such as colleges, trade schools, and technical schools. All right, thanks to everyone who said hello in the chat. It looks like we've got a lot of folks from the central part of the state, but also some folks from out in Pittsburgh and Philly as well. We are so glad that you're all with us today. And with that, I'd like to jump into our fair housing laws. Before I advance the screen to share about the goals of fair housing, I'd love to hear from all of you in the chat. Would you be able to share with me what you believe the goal of fair housing is? What are our laws seeking to accomplish? Why do we have them? What's the goals behind fair housing? I know we're starting out with a big question, but I would love to hear your perspective before I move on. All right, tenants' rights, absolutely. Tenants do have a lot of rights under fair housing, preventing exclusion from housing, reverse redlining and preventing discrimination, non-discrimination, avoiding housing discrimination. Absolutely. Thank you so much for sharing. So at PHRC, we talk about the goals of fair housing as two goals. So the first, ending housing discrimination, making sure that no one is kept out of housing opportunities through discriminatory acts and policies and practices. But beyond that, goal number two, which I don't think is talked about enough, is promoting diverse, inclusive communities. In the fair housing world, that's known as affirmatively furthering fair housing. And that's defined as taking meaningful actions in addition to combating discrimination that overcome patterns of segregation and foster inclusive communities that are free from barriers that restrict access to opportunity based on protected characteristics. So as I saw in the chat mentioned, there have been previous policies such as and practices and laws such as redlining and exclusionary zoning and deed restrictions and all of these different things that have created unequal housing opportunities and structural barriers to accessing fair housing. So it's not just enough to prevent discrimination from happening. We also need to look at where there's discrimination baked into our housing system and how we can work to make sure that all of our neighborhoods are areas of opportunities and how we can overcome those patterns of segregation. I do see that there's some additional comments in the chat, so thank you for sharing about fair banking and fair lending through the Community Reinvestment Act, fostering home ownership and accessing financial assistance to be able to access fair housing, because those are all parts of fair housing to make sure that folks can access all of those different areas of housing. So what do our fair housing laws cover? They cover the sale and the rental of housing, as well as housing-related transactions. So the sale and the rental of housing, that's relatively straightforward, right? Buying and selling a home, securing a rental home. What do you think housing-related transactions might refer to? I'd invite you to put any ideas that you have into the chat. And while I wait for folks to enter that, I'll continue going over the content of the slide. So the types of housing that are covered by our fair housing laws include apartments, single-family homes, manufactured housing communities, condominiums, public housing, nursing home, dormitories, and more. And there's two main types of discrimination or discrimination theories that I want to highlight. So the first one is disparate treatment. So that's treatment that directly discriminates against a member of a protected class. So looking at the protected class of disabilities, that might be a person with a disability going to apply for a rental unit and the housing provider denying them because they don't think that person can live independently in their rental housing. So it's treatment that excludes someone from housing directly because of their protected class. Disparate impact can be a little bit more subtle. So it's a policy that's neutral on its face, but it has an impact, a disproportionate impact on a member of a protected class. So looking again at the protected class of disability, it could be a policy that a housing provider has that all tenants need to have full-time employment. So we know that that individuals with disabilities have lower rates of employment than individuals without disabilities. So this may have a disparate impact or a disproportionate impact on members of a protected class and excluding them from housing opportunities. So thanks to those of you who put thoughts in the chat on housing-related transactions, including good cause legislation and ADA enforcement in housing. When I think of housing-related transactions, I think about home appraisals as someone's looking to buy or refinance a home, appraising the value of that house, getting a mortgage, and those lending institutions that support home ownership, as well as insurance, whether that's homeowners insurance, renters insurance, all of these various industries that can impact housing opportunities and the affordability of housing opportunities for individuals. So we have various levels of fair housing laws. We've got laws at the federal level, which include the Fair Housing Act of 1968, as well as Section 504 of the Rehabilitation Act of 1973 and the Americans with Disabilities Act, which provide additional protections for individuals with disabilities. At the state level, as I mentioned at the beginning of the presentation, we have our Pennsylvania Human Relations Act. And then at the local level, we have many different local ordinances that provide additional protections to municipalities and counties that add in additional protected classes that might not be present at the federal and the state level. I'd invite anyone to pop in the chat if you have a local ordinance in your area, a local human relations commission that provides additional fair housing protections. And I'd also like to cover housing jurisdiction. So what housing is covered? It looks a little bit different at the federal and at the state level. So under the Fair Housing Act, housing providers with 4 or more properties need to comply with our fair housing laws, unless they're publicly advertising their vacancies or receiving federal funding. And then at the state level, it's housing providers with 1 or more properties. Excuse me for just a moment while I make sure that both of our ASL interpreters are able to be seen. Give me just a moment and we'll continue this presentation. All right, I apologize for that delay. I think we've got all of our settings correct now. Let's see, I want to talk about the filing timeline as well. So under the Federal Fair Housing Act, a complaint has to be filed within 365 days from the date of the last harm. So up to a year. Someone can file with the U.S. Department of Housing and Urban Development, HUD, as it's known. They can file a complaint with that agency to have it investigated. At the state level, under our Human Relations Act, a complaint must be filed within 180 days of the date of the last harm. So that's about 6 months. So it's a little bit of a shorter time frame. But before I advance the slide to show you our protected classes, I'd love to see how many of those we can come up with in the chat. So I already highlighted in my example the protected class of disability, but I'd love for anyone to share any other protected classes that you're familiar with that have fair housing protections. Feel free to go ahead and put that in the chat. Age, absolutely. So age 40 and above, that's covered under our state protections. Age again, source of income is protected in several municipalities throughout the state, but that's actually not at the state or federal level. But that's a good one. Anything else? Thank you, Deborah, for that comment about the City of York Human Relations Commission. Yeah, I do know that has additional protections beyond what's available at the federal and the state level. Are there any other protected classes that you all are familiar with? Groups of individuals that have protections in housing? If not, that's all right. We've got a slide on that and we'll go over that. LGBTQ, yes, we'll be talking about that in just a minute. So you can see on the slide here, under the Fair Housing Act, there are 7 protected classes that are established. So that includes race, color, national origin, familial status, religion, sex, and disability. And you can see that that's closely mirrored at the state level as well, but we add on 3 additional protected classes. So we add on age 40 and above, ancestry, as well as the use, handling, or training of support animals for disability. And I'm going to go into a little bit more detail on familial status, on sex, and disability. Melody, that is a great question, and we're going to talk about that in just a minute. And the question was about sexual orientation and expression and their protections in the PHRA. They are protected, but they are not listed as separate protected classes. But before we get there, I want to touch on familial status. So that's defined as families with children under the age of 18 who are living with parents or legal custodians. It includes people who are pregnant, as well as people who are securing custody of children under the age of 18, including foster children, not just biological children. There is an exemption for familial status, and that's for housing that's covered by the Housing for Older Persons Act. So you might be familiar with 55 and over communities or 62 and older communities. So those are communities that are set up specifically for older adults. So they may have restrictions on the basis of age, which can impact familial status, but they are exempted from that. If you are looking for more information, you can check out the Housing for Older Persons Act. All right, I see a question on families with children. What if those families are those with mixed immigration status? So immigration status does not impact fair housing protections. Next, we get to sex. So sex is a protected class under the Pennsylvania Human Relations Act. So you didn't see LGBTQ, you didn't see sexual orientation, expression, gender identity listed as separate protected classes on that list. However, PHRC finalized regulations in August of 2023 that defined the protected class of sex. And that definition that was established through those regulations includes pregnancy status, childbirth status, breastfeeding status, sex assigned at birth, gender identity or expression, affectional or sexual orientation, as well as differences in sex development. So that's all included under the protected class of sex. So if someone believes that they have experienced discrimination in their housing on the basis of their sexual orientation, on the basis of their gender identity, on the basis of their sex assigned at birth, they can file that complaint under the protected class of sex and have it investigated. So we use these regulations as we accept complaints, as we conduct investigations, and as we adjudicate cases. So you can learn more at the link on the slide, which again, I want to reiterate that we will send out at the end of the presentation. So you have all of these resources. You can learn more about those regulations. You can also access fact sheets on our website that provide additional information on this. We want to make sure that we're getting the word out there about these protections, so that way folks know that they do have these protections in their housing and they know how to file a complaint if they believe they've experienced housing discrimination. And the last protected class that I want to define in more detail is disability. So that's defined as a physical or mental impairment that substantially limits one or more of a person's major life activities. So some examples of this include caring for oneself, walking, seeing, hearing, speaking, breathing, learning, or working. It's not an exhaustive list, but it's just some examples of how a disability may limit someone's major life activities. I want to highlight that a disability might be something that can be seen and observed when you're meeting someone or talking with them over the phone, but it might be something that's not observable. And both types of disabilities are equally protected under our laws. So fair housing laws protect those who have a disability, those who have a history of a disability, and those who are regarded as having a disability. So there are a few exemptions that I do want to highlight. And individuals who are currently using controlled substances or illegal drugs, they're exempted from disability-related housing protections. Now, this doesn't include folks who are in active recovery. So even if someone has a history of using controlled substances, but they're not currently using, they're sober, they're in recovery, they would have disability-related protections. And individuals who pose direct threat to the health and safety of others are also exempt from disability-related protections. So if someone has a substantiated threat to the health and safety of others in the community, then they could be denied housing, and that would be exempt from disability-related protections. Melody, I'll see if I can find a more specific definition for you. I don't have precise wording at present, but I can look into that and see if I can get that to you after the presentation is over. All right, so now we're going to move on to discriminatory actions. If anyone has additional questions about protected classes, you can feel free to pop that in the chat. We'll get to as many questions as we can throughout the presentation, but again, we will have time at the end for any questions that have been missed. All right, the first discriminatory action that I want to go over is discriminatory statements. And that's defined as printing or circulating statements indicating a preference or a limitation related to a protected class. So examples you can see on the screen are near a Catholic school, perfect for empty nesters, near a Korean grocery, or great for singles. I'd love for you to put in the chat why you think this might be problematic in a housing advertisement. Why do you think we wouldn't want to use these words and phrases as we're advertising our housing? And I'll give folks a moment to put answers in the chat. Yeah, thank you. Stereotyping, absolutely. So they could be relying on stereotypes just to think about the needs and wants that people have in their housing. And to add on to that, I'd like to add that it can deter people from applying for housing based on their identity. They may see that your advertising is great for singles. Maybe families might be less welcome there, so they may not choose to apply. And yes, that is steering folks, steering them to certain types of housing or steering them away from housing on the basis of their protected class. And it is exclusionary. Looking at religious groups, absolutely. Second practice is making housing unavailable by refusing to sell, lease, finance, or otherwise withhold housing or commercial property. Some examples of this include a realtor who's not showing homes to a Latino couple because the seller knows that neighbors don't want those kinds of people in their neighborhood. Again, that's an example of steering on the basis of ancestry or national origin. A bank who's refusing to lend money to a pregnant woman because she can't prove that she'll go back to work once the baby is born. That's lending discrimination on the basis of familial status or on sex. And then lastly, falsely stating that a property or a unit is not available when it actually is, because the landlord thinks that the prospective tenant is too old to live independently. So that could be either on the basis of age or disability. A lot of times these protected classes intersect and there's overlap and intersectionality there. It's illegal to have discriminatory terms and conditions in housing, whether that's in the sale, lease, or financing of housing. So some examples include having higher fees for teenagers, charging an extra security deposit for households that have a service or support animal, because that's not a pet. That's an animal that does active work for that household to support someone with a disability. And then lastly, increasing monthly rental costs, but just for individuals or households of certain races. Also under discriminatory terms and conditions, discrimination in the provision of facilities, services, or privileges connected with ownership, occupancy, or use of housing or commercial property. So some examples of this include not allowing children to use the pool at the complex, ignoring or taking longer to complete maintenance requests for a tenant with a mental health condition, or unequally applying rules or lease provisions for women or for female tenants. I see a question in the chat about if someone wants a group home or residential services home for children, and local zoning ordinances do not allow that in a residential area. That's a great example of exclusionary zoning, zoning that restricts housing for groups of individuals at protected classes. And that's something that falls under policies that might have a disparate impact. So if you're concerned about a situation in your local community, I'd encourage you to reach out to us at PHRC, and we'd be happy to chat with you about the situation that that you have going on in your community. I next want to move on to discriminatory inquiries, and that includes making an inquiry or a record related to a protected class in connection with sale, lease, or financing of housing. So some examples of this include asking if someone has a disability on a mortgage application, or asking if a caller who's inquiring about an apartment for their age or if they have children. A housing provider should not be making decisions on the basis of someone's protected class, so they shouldn't be asking any questions about that either, because that's going to have the appearance of decision making on the basis of protected classes. Next, I'd like to highlight steering, and that's defined as attempting to induce listing, sale, or other transaction, or discourage purchase or lease by making direct or indirect references to the present or future protected class composition of the neighborhood. Some examples of this include encouraging families to live near other families in an apartment complex, or only sharing property listings in majority Black neighborhoods to Black home buyers. So it can happen in a rental or in a homeownership situation, but there is an excellent investigation if you're interested in learning more. It was conducted by Newsday, and you can see the link at the bottom of the screen. The report is called Long Island Divided, and it was looking into some realtor practices in that area. Next, I'd like to move on to predatory lending and redlining, and that's defined as targeting people for unfair or deceptive loans on the basis of protected factors such as race, sex, or age. So example of this is a recent settlement. I believe it was 2022 or 2023. There was a settlement of over $20 million covering 4 states in the greater Philadelphia area And this company was found to have distributed racist language about minority-majority areas, avoiding servicing minority-majority neighborhoods, and targeting their advertisements to majority white neighborhoods, really not providing equal access to lending products and services throughout the broader community. So there was that settlement. But there have been numerous other ones that have made the news over the past year or so as well. Next, I'd like to move on to unreasonable use of criminal history. So HUD has released some guidance in 2016, as well as more recently, which states that a person's criminal history cannot be the sole factor in denying housing. Arrest records can't be used in the application process. So the concern here is disparate impact on the basis of race. So we define disparate impact as a policy that's neutral on its face, but it has disparate impact on a protected class. And we know that our communities are policed differently, and communities of color are more heavily policed. So we know that there's a disproportionate amount of involvement in the criminal justice system among Black and Latino communities. So if a housing provider has an overly broad policy that has a blanket ban, which is when there is when no one with a criminal history can be admitted into housing or submit an application, then it's going to have that disparate impact. So HUD has provided some guidance on this, and it's recommended that a housing provider use multiple facts when approving or denying an applicant. And those factors could include reference checks, credit scores, income, and employment. And they should be using a case-by-case analysis, which includes the recency of the offense, severity of the offense, and mitigating circumstances. And there's a list of best practices that I'd like to go over, and you can find the link to them at the bottom of the slide here. So if a housing provider chooses to use criminal backgrounds screenings in their tenant selection criteria, which most housing providers do, they should have a written policy that's available to all tenants. They should make sure that there's evidence that policy actually does protect tenant safety or property. They should ensure that the policy considers the nature, severity, and recency of criminal background. They should be very careful when they're using third-party screening companies, particularly if they're using algorithm-based screening companies. The concern here is that they may be using data that has an inherent bias there that's amplified through their algorithm that would lead to the exclusion of individuals in protected classes. Housing providers should also communicate with that applicant, that potential tenant, about the basis of an adverse decision and give them an opportunity to address them if they are denied. They should also comply with state and local laws that would limit use of criminal background checks unless there are federal laws that would require exclusion. They should consider delaying looking at criminal history until all other screening criteria have been met. And they should conduct an individualized assessment that includes circumstances that surround criminal conduct, evidence of good tenant history, as well as evidence of rehabilitative effects. And as they're conducting these assessments, they want to do them in a fair way and only in clearly defined situations, so as not to introduce potential for bias in these screenings. All right, next we're going to move on to appraisal bias, and that's defined as the use of protected classes when determining the fair market value of a property. So there have been a number of different articles over the past few years highlighting this issue, and the term that's often used is whitewashing of a property. So we see this impacting primarily households of color who received a lowball assessment when they're looking to sell their home or refinance their home. A number of households have chosen to whitewash their property. So remove any family photos, remove any products or art or anything that would reflect the race and ethnicity of the family that's living there, and then have a white family member or friend or neighbor stand in for them when the appraiser came. And unfortunately, in many cases, they found that the second appraisal was much higher when the appraiser believed that a white household was living there. Now, obviously, a property's value should be based on the actual facts of the property, the actual characteristics of the property, not the folks who live there. And then appraisal bias is a huge issue when we're looking at the racial wealth gap and how home ownership plays into that. So there have been numerous federal efforts to address this, and there have been fair housing testing studies done as well. It hasn't just been anecdotal evidence. As they've done paired testing, they've actually they found that this appraisal bias does exist and that it is pervasive. So the Property Appraisal Evaluation Equity, or PAVE task force, was set up at the federal government with a partnership of numerous different agencies. They released a report a few years back, as well as action plans for next steps to address these issues. And you can find that link at the bottom of the slide there. The next discriminatory practice I want to highlight is sexual harassment, and this is a form of sex discrimination. It's prohibited by our federal and our state laws. And in 2016, HUD did release a final rule on this matter. So there's two main types of harassment. The first one is quid pro quo. That's a Latin phrase, this for that. And it's when a housing provider subjects a person to an unwelcome request or demand for sexual favors, and submitting is a condition for obtaining or maintaining their housing or housing-related services. So it doesn't always have to be specific and specific verbiage, but we saw this a lot during the pandemic when a lot of folks were unexpectedly out of work, unable to pay their bills, and stuck at home. And there were housing providers and property maintenance staff that took advantage of tenants and the situation that they were in. But no one should be in a situation where they're forced to make a decision about their bodily autonomy and their housing stability for themselves and their family. But beyond that quid pro quo, there's also a hostile environment. And that's when a person is subjected to unwelcome conduct that's sufficiently severe or pervasive, such as it interferes with or deprives the tenant of their right to use and enjoy their housing. So we've got some common sense tips for any housing providers that are on the call to avoid harassment claims. So making sure that they've got policies against harassment and ensuring that their staff gets regular training on this topic to make sure that everyone is fully aware. Making sure that staff and residents know how to report potential issues of harassment, whether that's harassment between tenants from a housing provider, the owner of the property, the manager, maintenance staff, even a third-party vendor. And housing providers should keep housing transactions professional with residents as well as potential residents, not initiating hugs, kissing, or other forms of touching, not making comments, especially regarding someone's physical appearance, refraining from asking personal questions, and not entering a residence unit unless it's needed for maintenance or inspection purposes. All right, the last discriminatory practice that I want to cover is refusal to make a reasonable accommodation or modification. So I'm going to go over the content on this slide, but while I do, I'd invite you all to put any examples of reasonable accommodation or modification requests that you might be aware of into the chat. So this protection is specific to individuals with disabilities who need a reasonable accommodation or modification in order to use and enjoy their housing. A reasonable modification is a structural change that's made to the premises. You're changing the physical structure. A reasonable accommodation is when there's a change, exception, or adjustment to a rule, a policy, a practice, or a service. Does anyone have any examples that you're aware of either a reasonable modification or accommodation that might be needed for an individual with disability? Yes, widening doorways, particularly if someone might have a wheelchair, they might need the doorways widened to be able to get through those. A ramp to enter doorways, absolutely. A chairlift, that's another one. These are great examples of reasonable modifications, as well as arm rails or grab bars for the bathroom. Can we come up with any reasonable accommodation ideas? Any rules, practices, policies, or services that might need to be adjusted for individuals with disabilities? Can you think of any examples in that space? Yeah, excellent. A change in rent due date for folks that receive SSDI or another form of disability income, reserve parking, and emotional support animals. Yeah, those are three of the big ones. Absolutely. Thank you so much for your participation on this question. All right, some reasonable modifications. It's discriminatory to refuse to allow a person with disability permission to modify and pay for those changes that enable them to use a facility. So a housing provider may require the residents to restore the interior back to the original condition at the end of their tenancy, minus wear and tear. If the housing provider is receiving federal funds, it's the housing provider's responsibility to pay for the modification, not the tenant. But if it's in the general private rental market and the housing provider does not receive federal funds, then it's the housing provider's responsibility to grant permission, and it's the tenant's responsibility to pay for those changes. So some examples, which we covered in the chat, great job everyone, include not allowing a resident to install grab bars in a bathroom or not allowing a resident in a wheelchair to construct a ramp. For reasonable accommodation, again, that's making a change to the rules, policies, practices, and services necessary to afford equal opportunity for a person with a disability to use and enjoy housing accommodation. Examples, which I think we covered all of these in the chat, include not allowing a person with disability income to pay their rent on a different date than other tenants, not designating reserved parking for an individual with a disability who needs it to access their housing, and not allowing a person with a disability to have a service animal or an emotional support animal when there's a no pet policy. And there's a link at the bottom of the screen there that has additional information about assistance animals. That was put out by HUD, and it's got a lot of clarity around a lot of the issues that surround ESAs and how to handle those requests. We don't have enough time today to get into all the details on ESAs and support animals, but if you have any specific questions, I'm happy to address those at the end of the presentation. But in general, for best practices, a housing provider should have an established policy that all of their staff is aware of for handling requests. Make sure that everything is documented in writing. Housing provider should only be asking information from the tenant about what's needed to process the request. So do they have a disability and what's that disability related need? They shouldn't be asking any detailed questions about medical history and conditions and things like that, because tenants have a right to medical privacy. Housing providers should allow sufficient time for this documentation to be submitted, but they also have a responsibility to respond back in a timely manner within 10 days as established by federal guidance. And a housing provider should be engaging in interactive dialogue to meet that tenant's needs. So if they do need to deny a request, if it's not reasonable, if it's causing a health and safety risk to others, if they simply cannot grant this request, what else can they do? What alternatives are available to meet those tenants' needs? It doesn't end with the denial. It needs to be a continued conversation to make sure that individuals with disabilities are able to have their housing needs met. All right, we are coming into the home stretch of this presentation. So we're going to cover briefly the complaint process, as well as housing resources before we open up for questions. First, I want to provide you with our contact information. If you believe that you've experienced housing discrimination, if you know someone who has, I encourage you to reach out to one of our regional offices. We've got all of our contact information there. You can also contact our main number, which is 717-787-4410. You can go on our website to get more information, and you can also shoot us an email as well. We do provide information on our social media, so you'll see that on the slide as well. Feel free to find us on any of those platforms, as well as on YouTube. We have a lot of great information and programs that are available on our YouTube channel as well. But in general, the process starts with intake. So if someone believes they've experienced housing discrimination, their first step is to connect with a member of our intake team. So they'll be asked to fill out a housing questionnaire to provide some basic contact information about what they experienced, as well as the person that they're filing a complaint against. And then it's the intakes team, their job to assess their information to see if this is a situation that our agency can investigate under our state law. Is it jurisdictional for us? But if it is found to be jurisdictional and it is a timely complaint, then the intake team will help the person to finalize their complaint, and then the person who is filed against will be notified. So in PHRC lingo, we call the person who files a complaint, they're called the complainant. And then the person who's filed against, who responds back to that complaint, they're called the respondent. But after that complaint is finalized, it moves into the investigation phase. So both parties receive that copy of that complaint, and then they're asked to provide a response and further information. They'll be working with a neutral investigator who's responsible for investigating if there is a violation of our state law. So this investigator is not working on behalf of the complainant or the respondent. They're trying to get to the bottom of the situation. And they do that by asking for documents, interviewing witnesses, holding a fact-finding hearing, sometimes going on site to the property, and seeking other ways to obtain evidence. We do have mediation services at PHRC, and those may be an option for complaints that are filed and jurisdictional for us, but it depends on the facts of the case and if both parties agree to mediation services. The investigator will also explore if it's possible to settle the case before coming to a finding. If the case does proceed to a finding, there's two possible outcomes. So the first one is probable cause, which means that there was enough evidence to establish that that discrimination did actually occur. No probable cause means that there wasn't enough evidence found to support a claim of discrimination. So if there's no probable cause, typically that's where the process ends. A complainant can appeal that decision, but otherwise that's the end of the road for that complaint. If probable cause is found, then that case moves forward. It's either conciliated or it advances to a public hearing in front of one of our commissioners or hearing examiners, or it's filed in court. And at this point, our agency is no longer neutral. We're seeking to find a remedy for the discrimination that occurred. I often get questions about, well, how long does a typical complaint take to wrap up? And unfortunately, it varies significantly. So the amount of time it does take to investigate this case does vary, and that's based on the evidence, how speedy the responses are from both parties, as well as other factors. Now, you might be wondering why someone would go through this whole process. Why would they take the time to work with an investigator, submit all this information, make the respondent aware of the issue? And there are some remedies that can be obtained through these housing cases. So they can get that reasonable accommodation or modification that they need that can be accomplished through the complaint process. They can get changes to the lease and other policies. If those policies are found to be discriminatory, that has an impact of making sure that both that tenant as well as other tenants from this housing provider have fair policies going further from that point on out. There may be required posting of fair housing notices so that folks are aware of their fair housing rights and responsibilities. And typically respondents are required to get fair housing training to make sure that they are fully aware of their fair housing responsibilities so that issues don't pop up again in the future. There may be financial remedies, which could include a reimbursement of fees that shouldn't have been paid, as well as out-of-pocket expenses associated with the complaint process. And money for humiliation and embarrassment, that's pretty similar to pain and suffering, and that's only for our housing and commercial property cases. That is not a possibility in our education and employment and public accommodation cases. But that can be another form of compensation that's received by the complainant. Lastly, there may be civil penalties that are assessed against the respondent. That's money that gets paid to the state, and that's the cost for violating our state law. I have a couple of examples of recent housing awards. Ranges anywhere from the tens of thousands to 1.5 million. And you can see that there is a wide variety of types of cases, anywhere from failure to provide accessible units, denial of reasonable accommodation, to sexual harassment, to revoking of a lease, and not addressing neighbor harassment based on race, discriminatory statements, and refusal to rent based on familial status. So we do see cases that are across various protected classes and different types of discriminatory acts that we've covered earlier in the presentation. We're so glad that you joined us today and that you're bulking up on your fair housing knowledge. But if you want further information, we would love to support you with that as well. I want to highlight our resources here. We've got our Fair Housing line, which is 855-866-5718. Please give us a call if you have a fair housing question, whether you're a housing provider, whether you're a tenant, whether you're a social service provider, or someone else with a fair housing question. We've got trained staff that are available to talk with you. We offer free housing training programs and workshops. We can offer them to your organization. We can come on site or provide them virtually, and those can be customized to your organization's needs. But we also offer monthly housing webinars, which you're aware of, or you wouldn't be here with us today. This is our Fair Housing and Power Hour series. There's a link there on the screen, which will take you to some recordings from previous ones, but I also want to highlight that we have a couple upcoming ones as well. On November 20th, we'll be talking about national origin discrimination. We'll be doing a deeper dive into what that looks like. And then in December, we are going to be talking about LGBTQ rights in housing and how our regulations establish those protections, and getting into more detail on that topic. So I encourage you to sign up for those. I will send out that link along with the slides, so you can go ahead and register for those, but you can also go on our website and check out what we have upcoming there as well. We have a program on PCN called PHRC Speaks that's going to be coming back in December. And that's a great way to deepen your knowledge on various fair housing and housing affordability issues. And we'll have more information upcoming as those episodes are available, but you can check out our back catalog on our YouTube page. And then we also have a report, the State of Fair Housing in the Commonwealth of Pennsylvania. That's a white paper that highlights some of our structural housing inequality issues. And I encourage you to take a look at that on our website. I do want to leave you with some additional contact information. I work out of our central office, and that's our address as well as our phone number. That is my email there. Please feel free to reach out to me if you have any questions or concerns. I'm always happy to answer questions, as well as our Fair Housing line there. You will see a QR code on the screen, and that will take you to a feedback survey. So that helps us get a lot of really valuable information on what you found really valuable about this presentation, what you would want to change for the future topics. We'd love to get your input. I'm going to put a link on the in the chat here as well, so you can access it that way if that's easier for you. I do want to also let you know that you can sign up for our Fair Housing Quarterly newsletter through that survey, and you can also get a downloadable certificate of attendance for this presentation today through that link. So please check that out if you are interested. All right. I'm seeing some comments in the chat and some questions, so give me a second to look through those and we'll take a look. All right, I see a question. Do you think that the drastic increase of rental properties may reflect a new version of redlining and housing segregation? That is a complicated question that I think would take a lot more time than we have to answer it fully. But I do think that we see impacts of redlining and housing segregation, all of those policies and practices that have happened in the past. We still see those perpetuated today. When you look at the data around social vulnerability and health and well-being and economic prosperity, you can see those ties between the areas that receive that investment and that financial contributions to housing stability. And you can see the areas that didn't and how that's impacted our various communities. I know that the increase in rental costs has impacted a lot of communities pretty significantly, and that's destabilized a lot of housing stability across the Commonwealth. But I think that's a complicated issue that will take a lot of different efforts in order to fully address. And you can read a little bit more about PHRC's approach to that in the white paper that I referred to just a minute ago. All right, I'm scrolling through to see if there's any other questions that I missed. If there's anything, any questions that I didn't address, please feel free to pop that back in the chat and I will do my best to answer that as well. I appreciate your time in joining us for this presentation today. And I encourage you to join us for future Fair Housing and Power Hours as well. I will hold on the line for just a minute yet to see if there's any other questions that arise. I do see a question in the chat. Is it legal for landlords to increase late payments without notice? So late payments should be included in the terms of your lease. So typically you can't, this is more geared towards landlord-tenant, the Pennsylvania Landlord-Tenant Act and the protections that are contained within that versus fair housing. But any increase in late payments should be done around the time of lease renewal, since those are the terms of the contract that are set out. And you can talk with legal aid or another attorney if you want more detailed information on that. All right. Well, you can look in your email for the recorded presentation, for the slides, and some other resources that we'll be sending out within the next couple of days. But with that, I'm going to close out today's presentation. Thank you again for joining us. Thank you to our ISL interpreters, as well as our captioner, and thank you all. Enjoy the rest of your day.